Okay, civil rights. So we just talked about civil liberties, which are guarantees in the Constitution against government intrusion. Civil rights refers to guarantees to not be discriminated against um, by not only the government but then people as well. So civil liberties is protection against government. Civil rights, protection against discrimination from anywhere, including private individuals. So here's the definition of civil rights. Policies designed to protect people against arbitrary discrimination, discriminatory treatment by government officials or by individuals. So, civil liberties, talking primarily about the government, civil rights adds in individuals. And obviously, some of the big ones racial discrimination, the history of racial discrimination in the country, history of gender discrimination in the country, and then also some other more recent forms of discrimination, age, disability, sexual orientation, things of that nature. So this is a very important chart, and what this is talking about is when federal courts look at instances either in the use of the law for discrimination or discrimination by a company or an individual in hiring practices or others, they look at the basis of the statute or the conduct or the rule or whatever, and then apply our particular standards. So the basis of classifying people in a statute or in a hiring phase or something like that is based on race. Then the court views classifying people on the basis of race as inherently suspect, right? We're very suspicious of classifying people by race for any reason. Um, and so you have to have a very good reason. You have to have a compelling governmental purpose, and the only way to reach a goal, that's what you have to have in place in order to survive and have a rule like that be held as constitutional. So in that situation, what possibly could justify that, right? Well, classifying people in a census by race, right, helps us know how many um, minority populations we have in a certain district. So having a law that says you can ask people about what their race is on the census, Taylor is kind of we have a strong purpose in knowing how many minorities are in that area, and then also it's the least restrictive way to understand that number. So you can ask and classify people on a census by race, and that's okay. But let's say there's a different law that said, all right, well, we're gonna classify federal workers by race and then determine the pay scale accordingly. Um, that in and of itself, making any kind of distinctions on race, there would have to be a compelling reason to do so, and that there just isn't a compelling reason to separate people by race for the purposes of establishing payroll. So a law like that would be held to be unconstitutional. Now, that's on race. So there's a standard for race, and it's the most difficult to meet. It's the hardest one to pass if you're passing a law that's based on race. Gender is the middle standard, right? So there are certain things that can be classified between males and females. Um, it's moderately difficult to meet, so there still are differences between the genders, and so the test over there on the right for gender is, does the classification bear a substantial relationship to an important governmental goal? So this is not as difficult to meet as in race, because you can separate people out by gender, but under that same test, um, separating people out by gender, if there was a law that says you can separate people out by gender to establish payroll, you would not expect that one to meet the intermediate standard, because again, there's no substantial relationship to an important governmental goal. There's no goal that should be obtained by separating genders for payroll purposes, right? Um, but in terms of um, you know different occupations, there can be rules that establish differences of maternity leave, for instance, um, under the different statutes that allow for that. So if you female maternity leave may be longer than male maternity leave, um, and therefore you can have laws that allow for that, right? Insurance differences depending on laws that allow different premiums for genders based on the ability to be pregnant as a young person and those kind of things. Other types of discrimination, so age, wealth, those kind of things. It's the lowest standard that you have to meet, so that's easier. It has to be reasonable, and so the standard of review is the law has to be reasonable if it's going to discriminate on the basis of age, wealth, sexual orientation, those kind of things. And so then the question is, does the classification have a rational relationship to a legitimate governmental goal? And many of the homosexual rights cases and those kind of things have been falling under this standard, and the courts have been saying no, it does not even meet the rational basis test, and therefore would not be constitutional for the Defense of Marriage Act and some of these other federal acts that separate according to sexual orientation. So those are the three different standards. The lowest one, the reasonableness standard, is the easiest one to accomplish for a statute. So there's not as much protection given to those types of discrimination. There's great scrutiny, or there's not as much scrutiny given to those types of discrimination as compared to gender discrimination, and especially racial discrimination is highly suspect. Excuse me. So, our conceptions of equality have evolved over the centuries of the country, and so initially, it's a question of giving equal opportunity, and then the question is, through affirmative action and other things, do we guarantee equal results? So is equality of opportunity between all the races, genders, orientations, that kind of thing, is that what's really important, or do we demand equality of results? And then the question always is, how do we build an equality for opportunity, and then obviously what methods would we use if we want equal results? The Constitution initially, as you know, counted African Americans as 2/3 of a person. Eventually, after the Civil War and the Civil War amendments, we had the 13th, 14th, and 15th Amendment, with the 14th Amendment allowing for equal protection and due process. However, from the 1860s to the 1960s, as we well know, the language of that statute was not fully born, especially for African Americans, and everyone, right? There was not the kind of movement towards equality that the law required in those areas. So the era of slavery, initially 2/3 of a person. Slavery is allowed in the South. Plantation owners had a lot of political power in the South, and then therefore had a large block of control in the Congress as well. And so the Dred Scott case in 1857, this is before the Civil War, but it was a big controversial case at the time. The Supreme Court at that time, Justice Roger B. Taney, in one of the worst Supreme Court decisions of all time, didn't just decide the case. He went on to try and uphold slavery the best that he could by saying slaves had no legal rights. They were anything more than a plow or a tractor. They didn't have rights any more than a shovel or a pick or something like that. And said that the Missouri Compromise, which had said, all right, well, slavery can't be, there can't be any slavery north of Missouri, um, and it will stop there too. The Supreme Court invalidated the Missouri Compromise, and really was one of the major pushes towards civil war was that case. Now, once the Civil War was ended, obviously Abraham Lincoln's Emancipation Proclamation is huge, and then in the movie Lincoln, it's portrayed the passing of the 13th Amendment, which was also huge because it meant that the country was not going to deal with slavery anymore. It was going to be completely abolished everywhere throughout the country, right? And so that 13th Amendment abolishes all badges and incidences of slavery and outlaws it in the country. And it was difficult to pass. And think about it, at the time it was passing, the Civil War was not over yet. So many of the states had not come back into the Union at the time it was passed. But once the South was conquered and came back in, the 13th Amendment was there waiting for them, outlawing slavery. Now, during the first 10 years of Reconstruction after the Civil War, there were federal troops down in the South kind of maintaining order, right? And so you saw some tremendous gains in civil rights that were completely unheard of prior to the Civil War. So African American men held offices in Congress. There was voting rights. For a brief time, African Americans enjoyed a lot of the rights that were then going to be completely denied to them after Reconstruction. So the election of Rutherford B. Hayes, there was an agreement that the federal troops would leave the South, and they did. And once the federal troops left the South, then the Ku Klux Klan, the other Southern politicians took back over and created home rule, meaning that the North wasn't going to interfere with how the South ran its racial policies. And so all kinds of Jim Crow segregation stuff came back in, and the Ku Klux Klan was part of enforcing the laws outside the laws, enforcing white supremacy and other guys. Excuse me. So then with segregation, we later had the Plessy v. Ferguson case in 1896, where the Supreme Court upheld segregation and said separate but equal is just perfectly fine, and therefore segregation is fine. And so in 1896, again, this is 30 years after the Civil War, Plessy is decided, saying you can segregate as much as you want. And so the South did just that, right? And the 15th Amendment, which guaranteed the right to vote, there was all kinds of laws passed in the South, particularly requiring money, a poll tax, so you had to pay to vote. And they intentionally did that because a lot of the folks could not afford that. And so they intentionally added a price to paying for voting and did that in an effort to keep blacks from voting. They also just would require different tests, so you had to take a big test to vote, prove you were intelligent or could answer the questions, and it was all just a big game to try and prevent people from voting. So in Plessy, separate was okay as long as it was equal, and that opened the private sector, so your diners, your factories, your businesses could discriminate as much as they wanted to. And obviously the results were things were separate but were greatly unequal. So gradually Plessy was rolled back. So in McLaurin and Sweat v. Painter, higher education segregation was not upheld; it was struck down. And those cases for higher education, meaning college. And then the big case in 1954, Brown v. Board, where elementary and high school education were found to, and segregation was basically overruled because separatism is inherently unequal, and Plessy was directly overruled in Brown v. Board. Now, de jure discrimination is a direct discrimination. So that's a Latin phrase. So de jure means you've been discriminated directly. All right. So someone is directly writing a law or establishing a policy that discrimination against you. De facto discrimination is a set of policies that aren't directed at a certain person, right? But by default, so de facto is kind of like default. By default, they are discriminatory. So if you require, you know, certain things for qualifications for employment, and the goal is similar to the poll tax. The goal is to weed out minorities from applying, because you're playing the percentages that more minorities don't have this certain um, qualification or something like that to apply, or you know you live in a largely Hispanic population, and so you write a written test, not only in Spanish, and you don't do it in Spanish, you do it in very difficult English or something like that. What you're trying to do is discriminate against a certain population by default and how the policies are being run, and that's de facto discrimination. So both of those are eventually ruled and can be overturned as an unconstitutional form of discrimination. And here's just some overview of history in regards that we just kind of walked through with slavery. And you see Dred Scott there in 1857, and then shortly thereafter we get the Emancipation Proclamation and the 13th Amendment. But obviously that's not where the story ends, right? So then 14th Amendment was huge though, because almost every civil rights lawsuit now is brought under the 14th Amendment. And remember, the 14th Amendment and the Fifth Amendment applied to the federal government. The 14th Amendment applied to states. But what the problem was, for a long time, from 1860s to the 1960s, the courts would say, well, yeah, the 14th Amendment applies to states, but this local diner is a private diner, and therefore can discriminate because it's not part of the state. So for a long time, the courts played the game of, well, there's no state connection. It's not the sheriff. There isn't anybody discriminating on behalf of the state. It's just this private diner that's doing it, and that's okay. Well, eventually, with the Civil Rights Act and some of the subsequent cases there, they said no, discrimination anywhere is still a badge of slavery under the 13th Amendment, and that was outlawed with the 13th Amendment. And so they were able to kind of give equal protection at that point. You see some of the different cases there. So Brown v. Board, 1954, the court ordered integration and busing of students. Again, that was difficult for the court to enforce. They don't have the police force. So it had to take the president and the National Guard there on the ground, actually forcing black students to be going into the schools and being safe on the bus and things like that. So the federal troops had to go back into the South, so to speak, to enforce this. The Civil Rights Act by Lyndon Johnson in 1964 was another extremely great step forward in the area of civil rights. So it made racial discrimination illegal in many areas, created the EEOC, which is to investigate any kind of claims of discrimination, and it strengthened voting rights legislation, so you couldn't be outlawed from voting anymore if you were African American through the kind of the Jim Crow stuff. Jim Crow was just a set of laws that tried to prevent African Americans from achieving their rights across the board, the rights to vote, have freedom of speech. The Jim Crow laws were designed to prevent African Americans from really having rights. So this is just a chart that shows the percentage of black students attending school with white students in southern states. And as you can see, it took the Civil Rights Act and enforcement of it to really start taking effect. in the later 60s and early 70s when integration happened more and more. So this is kind of the modern history of the civil rights movement. Brown v. Board, we talked about Martin Luther King Jr. At the beginning of class and the tie-in there, and don't underestimate again the ability to tie kind of the all men created equal protection of the laws in the 14th Amendment. There's this equality narrative that runs through the country, and now newer groups, no matter where discrimination is claimed, newer groups try to follow the same path that the civil rights leaders followed in African American rights. And so you see different steps there in the fight for equal rights by African Americans. The Voting Rights Act again upheld voting rights in the South. You see several different cases. You couldn't have in Bakke, you couldn't have rigid racial quotas, so you couldn't. And it was a medical school in California that said, all right, well, we need this many black people, this many white people, this many Hispanic people. And the court came back and said, no, you can't just set quotas like that. That's not a good way of doing things. And so you see it's kind of the more modern history of the civil rights movement. 95, affirmative action programs that had to go understood. So affirmative action were situations where the racial minorities were given specific preferences to help kind of boost them in academic postings. So affirmative action would say, all right, well, if you're a racial minority, we should give you more points to get into a certain school or get a job or something like that. And there's been a real reaction against affirmative action programs, saying that there shouldn't be any classification on race, even if it helps a racial minority. We just should move away from classifying based on race. The right to vote, 15th Amendment extended that, as we talked about before. Here's some of the things. There was white-only primaries, poll taxes, the Voting Rights Act in the 1960s, again by Lyndon Johnson, helped roll back a lot of the discrimination based on the right to vote. But we still see controversy. So there's a recent U.S. Supreme Court case that said the Voting Rights Act data that was used to point to specific districts in the South that had a discriminatory history in the area of voting. The Supreme Court came back and said, this is based on old data and old thinking, and therefore we should overturn that part of the Voting Rights Act and say they need to come up with new data. And that result shocked a lot of people because they thought the Voting Rights Act is still an important part of ensuring the right to vote in those areas. But it just shows you that those things are still somewhat controversial today, and will continue to be so. So the Smith and v. Allwright case ended those white primaries that were terrible. No more poll taxes by the 24th Amendment, and Harper, no poll taxes. And so the Voting Rights Act helped end all that, as we talked about. Other similar racial minority groups have had their cases. So in Santa Clara v. Martinez, Native Americans could not be discriminated against on the basis of their racial background. Hispanic Americans, the same kind of thing. Asian Americans in the Korematsu case in 1944. That was the case about when FDR, so Franklin Roosevelt, put all of the Japanese in internment camps, and Korematsu said that's not allowed, and the Supreme Court struck down FDR's internment camps where Japanese were put into camps during World War II. Women in the battle for the vote. So in 1920, the women's suffrage movement was successful. The 19th Amendment added the women's right to vote in the country. But after that, um, it's known as the doldrums from 1920 to 1960, when many laws were passed that were designed to keep women in the home and protect women from vigorous labor and protect men from competition with women in the workforce. And so that was seen as a real um, kind of backsliding area of women's rights. There was a second women's feminist wave in Reed v. Reed, a law that said in court we're supposed to prefer men over females. That was struck down for certain probate cases. In Reed v. Reed, that whole statute was struck down. That was seen as a major case for women's equality. So here's some of the gender milestones. You see Reed v. Reed there in 1971. Civil Rights Act also covered gender discrimination. The Equal Rights Amendment was sent to the states for ratification, but it was not ratified. So that was the one when we talked about that one amendment that was not ratified. It was the ERA. And then you gradually see there's Pregnancy Discrimination Act. Sandra Day O'Connor becomes the first Supreme Court justice. And we also saw some different cases. So in the Morrison case against the Violence Against Women Act, that was struck down. But there was still the movement towards trying to better enhance gender equality and women's rights. So in Craig v. Bourne, the draft was viewed as not discriminatory, even though it only drafted males. So that was upheld as not discriminatory. Now we see there's a lot more women in combat for military roles, and so that issue seems to have gone away more. Wage discrimination and kind of the glass ceiling is still an issue that's there. The majority of corporate executives are still male, and does seem to be some wage discrimination between men and women, especially at the higher parts of corporate governance. And so those issues will continue to be issues. If Hillary Clinton is elected president, obviously then we'll have our first female president, and that would be one of the first for women in this country. Sexual harassment, there's been a lot of strides in that area, and a lot more training, and so that doesn't take place. Hope is that doesn't take place as much in the workforce as a result of expanding knowledge and education on that area. New groups that are active under the civil rights umbrella. Elderly folks, with the baby boomers kind of graying. The baby boomers will have tremendous amount of political capital because they just have so many people in their age bracket, and so you can expect to see a big push against age discrimination in the workplace, and in general there'll be a big push for rights for more elder Americans. Are the young a disadvantaged group? Are you a disadvantaged group if you're young? Well, obviously, a lot of people do not think that you are an active voting bloc if you're a young person, right? You don't show up to vote consistently, and therefore it's tough to pay attention to a lot of the issues, student loans and other things like that you might be concerned about. But being politically active will help make up for that. Civil rights and people with disabilities. The American with Disabilities Act was a huge act that we saw a lot more ramps into businesses, courthouses, public places, so that people with disabilities can get in there. You see a lot of construction taking into account all those kind of new things, and basically the touchstone of that act is You have to do reasonable accommodations to people with disabilities. And what's reasonable? Well, if it's going to bankrupt your company to do some kind of accommodation, you don't have to do it, but you have to prove that it really would bankrupt you. And if you're building a building, you don't have any choice, right? But if keeping someone employed as an employee following a disability will require some technology that just isn't efficient and feasible, then that's not a reasonable accommodation. And obviously, we've had a lot of movement on gay and lesbian rights, and we'll have a Supreme Court case on that in the near future. This just shows some of the percentages. So this is an old poll from 2001, right? And it's likely that the percentages have only continued to rise by a lot in terms of how discrimination against homosexuality is being reduced. Affirmative action, as we talked about, this is a policy designed to give special attention to or compensatory treatment of some previously disadvantaged minority group. And so this is one of the ways that they tried to create equal results by saying, all right, well, we don't have many African American lawyers or doctors or many racial minority this or that engineers or something, and so therefore if you're a minority applying to one of these schools or applying for this job, we will give you extra points to create a more diverse student body, because we feel like that's an important type of thing to have. So eventually, though, the Bakke case came back and said, no, you shouldn't give extra points. We had a University of Michigan case that also said points were not allowed. Couldn't have quotas saying this many black students, this many white students, this many Hispanic students, that kind of thing. You couldn't do that, right? And affirmative action in general is now seen almost as a bad deal, because even so, Supreme Court Justice Clarence Thomas, who's African American, would say, even though he benefited from affirmative action when he was going to law school, he was viewed by his classmates as only being able to get there. Or there was always the question, well, did you really get here on that basis, or were you the recipient of affirmative action, or what? He didn't like being questioned like that. He wanted his place to be there to be legitimate, not have a question mark and asterisk by it. And Adirond was the same kind of thing. You couldn't discriminate in construction contracts. And here again, you see the kind of a reducing support for affirmative action, and it should be, the higher percentages are saying, it should be based on qualifications that aren't related to race in any way. So civil rights and democracy. Getting back to our point about how this impacts democracy. Equality favors that the majority always wins. So if you have the highest number, you should win the vote, win the policy, whatever. But the idea is you have to have the right to vote to participate in all that, and you should be given an equal opportunity to participate in the right to vote. And suffrage gives many groups political power, right? Civil rights increase the size of government, because government who has to enforce equality and enforce all these rules has to be big enough to do all that in all the walks of life that we see it. But the hope is that brings more people into the process and creates a better country, a stronger country, one where groups are not marginalized and left out of the conversation and of the democratic process. And it protects individuals against discrimination that they would otherwise face. So civil rights is an important step. You see with one of the recent cases in Ferguson, Missouri, and around the country, where there's tension between local communities and the police population. There's still civil rights issues out there that are being fought. And so these issues will continue to come up and be explored as part of the democratic process. So what standard do laws, this is just a review, what standard do laws that discriminate on the basis of race have to meet? If you remember, it's the highest form of scrutiny. And so, not intermediate, not rational basis, that's the lowest form. Substantial is not, that's the intermediate test, so it's got to be a compelling government purpose, right? Compelling is the highest standard for discrimination.